Good morning, Council. On behalf of Judges Stafford and McBrayer, welcome to the Court of Appeals virtually. This will be conducted just like a hearing in our courtroom. And
up in the upper right-hand corner.
And we will if we have any technical problems, we will fix them. We'll pause. We'll work it out. We've done it before. We can do it again. So if there are no announcements or questions, we can call the first case, Mr. Hivner.
Virginia Crawley versus Metropolitan Government of Nashville and Davidson County, Tennessee et al.
Okay. And I believe the appellant, you may begin when ready.
Thank you. Gina Crawley for Miss Virginia Crawley. I've requested to reserve 3 minutes for rebuttal.
That's fine.
So this case is really about toxins and recreation. And I'll begin with the toxins. On June 13th, Ms. Crawley specifically raised section 17.36.030. And that section deals with the PUDs, the Planned Unit Development's high protection standard. It also talks about well-planned and coordinated living, as well as dealing with environmental sensitive lands in light of increased density in exchange for the high protection standard. No arguments were made on June 13th by my friends on the other side about the toxins. Ms. Crawley was the only person who raised an argument with the toxins. Nothing from the commission, from the Ridge at Antioch, nor from Old South. It wasn't until after June 13th that these new arguments regarding the toxins emerged. One of them was that the toxins are irrelevant and speculative, but this runs counter to the record evidence, which shows that the Ridge's own experts went into the site, physically investigated the site, and found that there were toxins there. And this was not considered to be a de minimis condition. These toxins, the experts recommended that before any grading takes place, the soil should be removed.
Isn't there a remediation plan for that area where the soil will be removed and placed in an appropriate landfill?
You mean, was there a remediation plan in the record or?
Well, I understood that there was a plan. And that for that particular area of soil to be removed. Is that correct?
Well, that was recommended by the experts. As far as a plan being in the record, I'm not aware of one. I know that the experts, as far as their report, they did recommend that the soil undergo additional testing, like toxic leaching procedures testing, different types of tests that the soil has to undergo before it goes into the landfill. Whether or not that report was actually followed or mandated, that is unclear. At this point, the experts' reports are still just recommendations. So I'm not aware of anything that's required to be followed at this point. And there's nothing in the record, I don't believe, to support that other than the experts' reports, which at this point are still just recommendations. And that was part of the concern with Ms. Crawley that she raised, was that these toxins, nothing was really said about it at the commission. Another issue too that was raised too, and Judge Bennett, did I answer your question?
I believe so.
Okay.
I believe it has been raised enough so that your opposing counsels will address it as well.
Okay, thank you. Also too, my friends on the other side have also said that the toxins are limited to section 17.28.020. But that section does deal with environmental concerns, and there are like 4 listed in that section. But also too, on page 11 of my reply brief, I list a whole host of other sections within the ordinance which talks about environmental concerns without referencing section 17.28.020. And so what that signals is that the council was not limiting the environmental concerns to just those mentioned in 17.28.020. If they were, then they would have stated it in those other sections as well. In particular, I'd like to talk about one now, which is the one that Ms. Crawley raised, which is 17.36.030. In that one, it specifically talks about environmentally sensitive lands in light of the well-planned and coordinated living. And that section does not mention 17.28.020. And when Ms. Crawley raised these environmental issues at that point, and this court has noted this in Ryan, which is an unpublished opinion, but in that case, an issue was raised, and this court has found before that once the issue is raised, it could trigger a duty, at least on the part of the commission or the board, to do further investigation. And in this case, that duty was triggered in light of the toxins and the reports that the experts, and in light of the experts' findings. There was also an argument about preambles as well too, made by my friends on the other side. In particular, they relied on two cases. One was Venture Holdings, but Venture Holdings dealt with the resolutions preamble and not one dealing with an ordinance. And the Father Ryan High School seemed to indicate that the very first section of an ordinance could be the preamble. It did not indicate that there will be preambles embedded within the same ordinance. And so the very first section of this ordinance is section 17.04.010. So it seems like that section would be the preamble and not the sections that come after it. Moreover, Father Ryan High School did not deal with the interplay of planned unit developments in light of the rules that the council has laid out for how this ordinance should be construed. And so usually when construing ordinances, we look at the rules of statutory construction. Is what the case law has found, that the same rules that apply to the statutes also apply to the ordinances as well. And so next I'll move on to the recreation. Now in June, Ms. Crawley specifically raised section 17.36.070. Now that section deals with the clustering of single family and two family units. Now by definition, they are constructing townhomes. Townhomes by definition is a single family. Also, these townhomes are sharing a common wall, which means it meets the definition of two family as well. Now my friends on the other side have argued, first they've cited no provision or nothing to really contradict Ms. Crawley's interpretation. But they did argue that recreation is not required because the government said so. Now, in the North Shore Corridor Association, on a panel that Judge Bennett was on, this court found that in that case, the proponent was confusing the material evidence standard with the statutory interpretation standard. While this court certainly may take into account a government official's interpretation, it's not bound by that account. What's the determining factor is what the council has said. The ordinance is what sets the guideposts, not what an official's interpretation is. Also too, they've also argued, my friends have, that laws are generally construed in favor of the property owner. And while that generally is true, there must be two bars met before they can reach that. One is that there must be an ambiguity finding. And again, my friends have not argued that the ordinance is ambiguous. And also, the land use must be compatible. Here, when the recreation was removed, it created an incompatible land use. And when that happens, the case law requires that the use be construed against the landowner. Another argument, and the last argument made by my friends, were that the recreation was not needed because because the residents are going to be elderly. But again, if you go back and read the ordinance 17.36.070, there is no exception that the council created, which says you don't have to include recreation when the population is elderly. There's no such exception created within the ordinance. As a matter of fact, the council is actually required that whenever a person does develop within that parcel, the recreation has to be unique to the demographic. So just on the plain meaning of the the language, recreation was required. Just as when we look at the plain meaning of section 17.36.030 about this high protection standard that was imposed upon PUDs in light of considering these toxins, some sort of consideration, some sort of conversation was required to be had about these toxins before this development could move forward. And at this point, I'll yield the rest of my time now unless the panel has questions.
I don't see any, so thank you, Ms. Crawley. Now, it looks like we have a plethora of people on the other side. Are you divvying up the time, or how is this going?
Yes, sir. Mr. Pennington is going to start, Your Honor.
Okay, and we have 1 minute up there. So, Mr. Pennington, you're getting 1 minute. Okay. You may proceed.
Sure, you unmute.
Okay, can you hear me?
Yes.
Okay, thank you. May it please the court, I'm Tom Pennington of the Nashville Bar. I represent the Rigid Antioch LP, whose sole role in this lawsuit is as the predecessor in title to Mr. Dean's client, Old South Craighead joint venture. My client sold all of its interest in the property and the project to Mr. Dean's client. And to the extent we have any interest in the way that this lawsuit turns out, our interest is entirely in line with Mr. Dean's position. So with that, I will yield the balance of my time to Mr. Dean.
Okay. Mr. Dean, it looks like we're giving you 6 minutes. Is that right?
That's correct, Your Honor. Thank you.
All right, you may begin.
Your Honor, as Mr. Pennington just said, I represent the joint venture Old South Craighead. They applied for approval of what's called a minor revision to a planned unit development. And I'll talk about that a little bit more, although briefly in my few minutes. Essentially, what they were going to do, Your Honor, is change one section of an already approved planned unit development, mainly by decreasing the number of units from a previously approved 96 units down to 56 units. So actually moving the number of residential units down from the previous approval. Actually, when the PUD was originally approved by the Metro Council, it allowed 212 units in this particular section. So you can see it's almost 75% down. Property is located at 2858 Murfreesboro Pike. And the application was what they call a minor revision, Your Honor, because the planned unit development had already been approved in principle, and actually a fairly complicated set of plans were submitted. I might just take 30 seconds to describe the planned unit development. I know the court has considered these kinds of zoning techniques before, but just as a quick refresher, essentially a planned unit development is a project where a zoning change takes place and it is accompanied by a set of complicated plans for how the property exactly is going to be used. In an ordinary zoning change, you might change it from, let's say, a business zoning to a residential zoning, but you wouldn't specify where the buildings are going to be, how many units. The specifications are left vague in a regular zoning change. On a PUD, they're very precisely noted on the plans. For that reason, from time to time, you have minor revisions. If there's a significant change, it's an amendment, has to go back to the Metro Council because the council wants to see it. For example, suppose we'd started at 56 units and we're now asking for 212. The council would want to look at that because increasing the number of units is something that the council usually is concerned about, increasing the possible land use impact on surrounding land uses. In this particular case, though, because there were no kind of change that would require councilmanic approval, this simply went back as a minor revision to the Metro Planning Commission. Planning Commission had reviewed these plans a couple of times in the past. As I say, the main change here was a decrease in the units. Your Honor, here the the plaintiff makes two arguments, essentially, recreational and environmental. Let me start with the environmental. This is addressed on page 19 of our brief. And just from our perspective, Your Honor, it's fairly simple. The petitioner is looking at it from a very broad stroke, and I can understand that from their position, but the zoning ordinance restricts, the Metro Council has told the Planning Commission what it's supposed to look at in terms of environmental considerations. Those are found at the zoning ordinance section sign 17.28.020. And there are four basic things that they look at. Hillside development standards. If you have significant slopes, the Planning Commission is supposed to look at those in excess of 15%, any slopes in excess of 15%. Planning Commission is supposed to take special consideration of those. There are no such slopes on this property. The second criteria is special flood hazards. If you've got low-lying property and it has special flooding problems, again, the Planning Commission is supposed to take a look at those and give them special consideration. Again, no special flood hazard on this property. Special soil problems relating to particular kinds of soil, which are identified in the Davidson County Soil Survey, which is found outside the text of the zoning ordinance. That this property, again, does not have any of those soils on the property itself. Finally, there's protection of cedar glade plants, communities that have those kind of plants. The Planning Commission is instructed to look at those carefully. None of the four environmental considerations that are subject to review by the Planning Commission applied to this property. And the Planning Commission got a recommendation from the staff saying that we meet all of the requirements, not just the environmental, but all of the requirements. And therefore, they approved the project on that basis. Turning to the recreational, Plaintiffs' Counsel has already alluded to this issue. And I confess to the court that I don't quite understand why Metro's regulation is this way. But the section that's involved, as the plaintiff indicated, 17.36.070, and it's discussed on page 29 of our brief, only requires recreational facilities on mixed residential developments. That is, you've got some single family and some multifamily. The staff said this is not that kind of a project. If you read the definitions in the code, it's not both single family and multifamily. I don't know, again, the underlying theory about that, but the fact is that we meet the requirement. In previous iterations, this had recreational property. We've taken it out, but we were permitted to do so because this is not a mix of residential development. It is simply one kind, single family development. So we meet all the requirements. The staff recommended approval. Planning Commission approved. Thank you, Your Honor.
Thank you very much, Mr. Dean. Okay, now let's see. We only have one person left. It must be you.
It must be me. Thank you, Your Honor. I'm Jeff Campbell. I'm representing the appellee Metropolitan government. And primarily, I'd just like to say that I don't want to replow already plowed ground, but I would reiterate that our position is aligned with that of Mr. Pennington and his client and Mr. Dean and his client, in that Metro, our position is that these were minor modifications, and therefore this was not required to go back to council. It didn't alter the basic development concept of the PUD, expand its boundary, change its classification, deviate from any specific already implemented, incurred Metro Council requirement, or increase.
These new units, the reduced number 56, are they single family units?
My understanding, and Mr. Dean can correct me if I'm wrong, my understanding that this was going to be multi-family townhomes, so that there would be between something like 6 and 8 in each. But I would defer to Mr. Dean on that, since his client's the one that's developing the property.
And I apologize, Your Honor. I think I may have misspoke there. They are townhomes, so multifamily rather than single family. I apologize to the court.
Okay.
So yeah,
then if they're multifamily, that doesn't trigger a requirement for recreational areas?
It does not. In fact, the language from section 17.36.070A2A reads specifically, recreational facilities. Any property owner or developer of a subdivision clustering single-family and two-family lots within a PUD district as provided in subsection A1 of this section shall install and or construct recreational facilities, et cetera, et cetera. So it says clearly there is no clustering of single and two-family units here.
Define clustering.
Well, you would, here there's not a cluster of anything. All the units are the same type. So there can't be a cluster.
So we're talking about a mix of an apartment building and other types of family homes have to be together before you have a recreational requirement?
You would have to have a single family and two family lots. That's correct. A cluster.
A single family and two family lots.
Single and two family. Yes. Not one or the other, but you would have to have both. And I think, as was pointed out, the Planning Commission staff who deals with this consistently indicated that was not the case here. And of course, as Your Honor knows, there's deference to the expertise of those administrators who deal with these types of things.
So these 56 townhomes are just multifamily.
Correct.
So you don't have any single family mixed in, so the requirement for recreation isn't triggered. Is that what you're saying?
That is correct. That's our position, and I believe that's Mr. Dean's position as well.
He's nodding, so I believe that's right.
So so that's Metro's position with respect to the recreational facilities. With respect to the potential presence of household waste, I think, as Your Honor has brought up, that actually is addressed in the record with a plan for remediation. However, I would agree with Mr. Dean that that's not really the bailiwick of the Planning Commission at this juncture. Rather, that's for the developer and the Tennessee Department of Environment and Conservation. So I think the appellant would actually is asking the Planning Commission to step outside of its role here, which the case law says is to, in the context of local legislative bodies sitting administratively, the local body's discretion to disapprove, for example, in the Binkley case, a local waste transfer station was limited to the criteria in the code. And so I think what Ms. Crawley is asking is that the commission go outside of what the criteria are that they're allowed to look at.
So in perhaps layman's terms, you're saying that under the ordinance, toxic waste isn't the bailiwick, or toxic soil isn't the bailiwick of the commission. It belongs with TDEC, and TDEC is dealing with it through the remediation plan that is in the record. Is that right?
That is correct. Yes. And
So
in
is my
addition,
whole statement correct there?
yes.
Okay.
And I would also just like to point out that, you know, her suggestion that the commission should consider the overall zoning scheme, it ignores that the Metro Council actually did do that initially and considered the PUD in the light of the overall zoning scheme in the first instance when it approved the PUD. And so, as Mr. Dean has pointed out, really all this has done is his client could have proceeded with building the 96 buildings. All they did was reduce the number of buildings from 96 to, I believe it was 56. So I think that's something that has already actually been considered by the council in approving the PUD in the first instance. And so with that, Your Honor, unless there are any other questions, I'll cede the rest of my time.
I see no questions. Thank you, Mr. Campbell.
Thank you, Your Honor.
Ms. Crawley, you have your rebuttal time. 3 minutes. Unmute, please.
Thank you. Thank you. So I'll begin with the remediation plan. As far as the remediation plan from the Tennessee Department of Environment and Conservation, that was not cited at all in my friend's brief. I would encourage the court to look through that, nor is there a plan from the Tennessee Department of Environment and Conservation that I could recall that is in the record. And I would just encourage my friends to, the court to look at my friend's brief to see if that remediation plan is actually referenced. That is not, was not cited by them, nor could I find that in the record. Also too, this is a mixture. And if you go through the brief, as you read my friend's brief, notice how they go back and forth between using the terms multifamily, townhome, sometimes multifamily. And the reason that they go back and forth is using it is because it meets that definition of single family and two family, which requires the recreation. And all the court has to do is just look at the face of the statute. Look at, of the ordinance. Look at what the ordinance requires. Townhome is single family. If you look at the map, they're sharing a common wall, which meets the definition of two family. And that's why there's that back and forth between in my friend's brief, is because they're going back and forth, is because of the recreation is required, because it's actually single family and two family units against a multifamily backdrop. It meets the definition for having the recreation. As far as the toxins was something that was required to be considered. Ms. Crawley is not asking the commission to overstep its boundaries or anything like that. All it's asking the commission to do is just to consider the toxins. Consider this in light of the development. This is what the council has asked. The council is the one that had put this high protection in place, this high protection standard in place for well-planned and coordinated living. It was the council that put it in place. The commission is bound by, and Ms. Crawley is asking that they just simply follow Title 17. Recreation is required under the ordinance, and that cannot be removed until the council says so. And if the developer wants that removed, then he has to go to the council and get permission to have that removed. But the council doesn't have the authority just to remove recreation when the council is requiring it that it be included. Also, too, the council is the one that put this high protection standard in place to protect the community. And they were required to consider the proposal against these known toxins. And so I would just ask the court just to remand this case, because without considering the toxins and the recreation, that's something that has to be addressed because it was required under the ordinance. And without considering that, in effect, the developer has amended the map without council's approval. And I would just ask that the court take a second look at the Northridge Association case and also the Moore case as well, too. Thank you.
Well, thank you very much. Thanks to all of you. A very, very interesting argument, and you've given us a lot to think about. Mr. Hivner, would you please recess court?
This honorable court